Good morning and welcome to Open Conversation on Atlantic Television Network. Open Conversation is the network's flagship political platform through which trending political news, events and stories are discussed. Conversations, ATN uses issues, party system and actor to explore hope and engender positive impacts to the society. Today on Open Conversation, we look at Rivers State. APP prays court to nullify local government elections. On Rivers crisis, Akpabio faces criticism over comments. On election, Benin Republic Electoral Commission in Nigeria to understudy INEC. On 2027, you can't fly. Wait till 2031, Ibukwe says to Atiku. And still on politics, Obasanjo part of Nigerians' problems, Lukman says. We are open for advert placements, bookings, and commercials. You can connect with us on all our ATN socials, Facebook and YouTube, Atlantic Television Network, Instagram and TikTok, Atlantic TV Network 1, and on Twitter, Atlantic TV Net. Watch us live on our website, www.atlanticnetwork.tv. Book on a short break when we come back.
As always said, there are two sets of people. The oppressors and the oppressed. And in between are the coward and the hypocrites, which I
have to challenge how high we are because we always overcome.
What Nigerians believe now is not about the government. Who can come and salvage us from where we are?
Welcome back and thank you for staying with us. Joining me on Open Conversation this morning is Honorable Don Oparaji, Esquire. Honorable Don is a legal practitioner, member, Nigerian Human Rights Commission. He's also the secretary on a Blueprint Development Committee. Good morning, Honorable Don, and welcome.
Thank you. Good morning.
And on to the story. Action People's Party has prayed a federal high court in Abuja to nullify the election victory of the party's candidate in the Rivers local government election held on October 5. The plaintiff, Juboye Abraham, in a suit marked FHC/ABJ /CS/1464/2024, filed by his lawyer, Obai Okairo, urged Justice Binta Yako to make an order setting aside the candidacy of the APP in the election. He also prayed the court to nullify all the votes cast for the state's local government chairman on the APP platform for being in breach of Section 225 subsection A of the 1999 Constitution as amended and the Rivers Local Government Law. ATL reports that in the suit dated and filed on October 4, Abraham sued the Independent National Electoral Commission, APP, and Rivers State Independent Electoral Commission as the first to third defendants in the suit. He also joined the elected local government chairman as the 15th to 26th defendants, respectively. Abraham is seeking a declaration that it is illegal, unconstitutional, and void for INEC to continue to keep APP in the register of political parties in Nigeria when it is manifest that the party is in breach of Section 225A of the 1999 Constitution. He sought an order compelling or directing INEC to exercise its powers under Section 225A of the 1999 Constitution to register APP as a political party registered in Nigeria with powers to field candidates in any election having been in breach of the law. He also sought an order of perpetual injunction restraining the RISIEC from placing APP logo on the ballots for October 5 Rivers local government election, having been in breach of Section 226A of the 1999 Constitution. Abraham further sought an order setting aside the candidacy of the 4th to the 26th defendants in the said election and nullifying all the votes cast for them being in breach of Section 226A of the 1999 Constitution and Rivers State Local Government Law. When the matter came up before Justice Nyako, Carlo Agu, who appeared for the plaintiff, informed that all the defendants had been served and the matter was slated for mention. When the judge asked him what the subject matter of the case was all about, he said the rest is about the non-performance of the statutory responsibility of the first defendant, being INEC. Counsel for APP, Obed Ago, said though they were yet to file any application, they intend to respond to the plaintiff's suit. Obed also told the court that the INEC lawyer was in court but stepped out before the proceeding commenced. The judge consequently adjourned the matter until February 5 for hearing. She ordered that hearing notices be issued and served on defendants who were not represented in court. Honorable Don, you are a legal practitioner. You are here specifically because of this particular story. What is your take on this development?
Anyways, good morning, Nigerians. Well, from the position read so far, first of all, we have to understand it's a constitutional issue. It is a matter that has to do with the holding of the sanctity of the Constitution. Like you had the plaintiff who was in court to request that the court gives life to the provisions of Section 225 as well as 225 paragraph subsection 1A, as much as Section 226 subsection 1 and 2 of the Constitution of the Federal Republic of Nigeria as currently amended in 2023. Now, what is the purpose of that provision? That provision is of the fact that the Independent National Electoral Commission shall have power to deregister any political party who is unable to score 25% of its total vote in any state of the Federation that has to do with the election of the President of the Federal Republic, any state of the Federation, there's any local government in a state that is unable to score 25%, for a governorship election, any local government chairman election, any, ward in a local government that's supposed to score 25% in a ward, And then when you go to the councillorship election, it applies in the same way. And that where the party cannot also secure one seat of the National Assembly, including the seat of the House of Assembly, in that general election, the INEC is empowered after that process to deregister that political party. That is what the plaintiff has gone to court. And you know, the matter is instituted by originating someone, asking the court to interpret and give effect to that provision. So for me, it is a good suit. For me, it is a suit, you know, that has to do with public policy, because anything that has to do with the provisions of the Constitution has to do with the public, because the effect obviously goes back to the public. So the plaintiff going to seek the court's attention to implement or give pronouncement to these provisions is not a step in the wrong direction. I feel it is a step in the right direction. And then going further, we have seen that this same party, which is not known, in fact, it was when they started advertising the issue of local government, whatever election that they called it, that I knew about APP. APP, in fact, is a far long gone party. It's a far long gone party. It's not a party that has activities within the country. We don't even know when they do congresses. We don't even see them, not to talk more in the state, like Rivers State. We don't even see them hold their political meetings, you know, just like PDP, APC, and Labour Party has been doing. So, obviously, once a party is formed, it's no longer a private affair. You understand? Their organization, their activities is supposed to be something that the public will know about, because it is not a secret court. So since it's not a secret court, that's the difference between a secret court and a political party. When was these people, when were they adopted as party members? I hope you understand. And then when you know, their dues and registration, how long have they been paid?
But this is not, these questions now, it's not part of this current prayer.
No, what the plaintiff is telling the court to do is to nullify the elections. These are the issues that the affidavits...
Is it to nullify the elections by empowering INEC to deregister APP?
Nullifying the...
He was not qualified to even field candidates for the local government election. Is that what you're saying?
Exactly.
So going by the prayers of this person, the prayers is that INEC, that APP originally should have been deregistered
before the October election. So in view of the fact that they cannot win any seat in that election, then what it means that the INEC is supposed to deregister them. Now, furthermore, in the October 5 election, so-called local government election that was carried out in this state, honestly, that election was cut down, okay?
National television. It's an allegation. Don't you agree?
Now, see, whether you like it or not, that is an allegation or not, without the governor's effort in Rivers State, APP is not a party known. You and me know. Without the governor's effort in Rivers State, where we had the party before the governor came into power, it was the governor that brainchild this whole thing. It was the, yes, that brainchild this whole thing, and then initiated the processes that led the allegiance as we speak today is all to the governor of Rivers State. They can't lie against it. They can't deny it. APP's allegiance in Rivers State is all to the governor of Rivers State. Okay. Without the governor, APP is nowhere.
Of Nigeria has amended the first constitution. He now said, if in the local government election and setting aside any benefit or privilege, this matter appears to be a lot is attached to it. Because now, apart from nullifying the election, it's also praying that the 4th to 26 defendants be disqualified as candidates of the APP.
Yeah, let me throw more light. See,
yes, go ahead.
This is a constitutional matter. And the plaintiff is simply bringing out all the indices, things that has happened within the period that this
That is
suit,
in breach of the Constitution.
that the suit was filed, and those that happened, you know, when this action took place.
Okay.
Those indices is what the court, what the plaintiff has brought before the court. The plaintiff election, going to the tribunal, there are certain conditions, of course, you have to fulfill. Now, going already with deposing his affidavit is also showed to that these persons are not even members of the APP before the election. I hope you understand. These were not members, registered members of the APP.
Can a political party give waiver?
Now, waiver.
And where does
Can be given, but you know, the Constitution, Electoral Act provides certain guidelines where waiver can be given. This is not the issue of waiver. The suit before the court is not the issue of waiver. The suit before the court is to ask the court to ask the court to instruct or order INEC to do what it is called in order of mandamus. To perform the order of mandamus, a public institution that is supposed to carry out a specific action. Failure to carry out the specific action, in fact, what in law, what the plaintiff has gone to do is to ask her to order this mandamus on INEC, asking them to do what they are supposed to do as a body, you know, giving responsibility to manage, control, manage, and supervise election. You understand? And political parties affairs. PP was registered so he could win a seat.
National Assembly, they don't have one candidate.
Not even councillor as at when the general election was held.
So,
do you understand?
Yes. So, and they did not win 25% at any
Not
level.
even a seat.
And at the national level, they didn't win any seats.
They didn't win anything. The only party that won was YPP with late Senator Ifan Yuba, you know, the YPP candidate from Anambra Central. You understand? That was the only party, of course, I can remember that won election in this 2023 election. APP didn't win any election. You understand? So on that basis, INEC ought to deregister them. That's what the plaintiff is going to court to do, or asking the court to do, to make an order of mandamus. Now, obviously, the truth is that if the court agrees with the plaintiff, it means that once it is deregistered, it can no longer be a vehicle for anybody to use. Not even the so-called local government election that was conducted. I hope you understand.
So in this instance, if the party is deregistered, it means that this local government chairman automatically...
If the relief sought are granted by the court,
the local government elections
obviously, in the eyes of even the law, I don't even see them as local government chairmen.
Now, at this point, in River State crisis, it appears that this River State crisis is not ending anytime soon. I mean, because the fight has been, I mean, the 2024 budget is under litigation. The appeal court judgment has held that the governor is in gross violation, and also held that the governor is in contempt of court. On the other hand, the River State lawmakers are battling with the alleged defection, and the matter also is in court. So now the executive has his own troubles, the River State House of Assembly has its own troubles, and now this is trickling down to the local government. How do you see this playing out? It appears that the River State crisis may not, at this point, I don't think I should be asking what is the way out. I should be asking what the implication of all these things will be on River State.
Let me break it. You see, I was on this show sometimes and I said, I use this your show to appeal and advise the governor of Rivers State. I said, any action, you can remember I said, any action taken by any of the parties will have a gross effect. No doubt the problem is not doing any good to the state. I must tell you, the problem is not doing any good to the state, because obviously a lot of people who are not in the political class are suffering because of this seemingly unnecessary animosity, okay, that is being demonstrated by the actors. And I said the governor should understand that he steers the government of the state in that class. The government of Rivers State is headed by him. And he must be conscious to understand that it is this constitution that brought him to power. He must do things in consonance with the provisions of the constitution. Part of the problem in this state is because there is a gross disobedience of the provision of the constitution. I'm not even talking about the FCT minister. Is the FCT minister the governor of Rivers State? No. The governor we are talking about, the actions of the governor or those around the governor. That's the problem. If the governor follows the provisions of this constitution, I don't think there will be a problem. Now, let me even tell you. Look at even the Rivers State Independent Electoral Law, okay, that RISEC, consolidated before they gave, before they fixed date for the so-called October 5th election. Section 13, subsection 4 of that law says RISEC will be able, should have power. The RISEC will give notice of 3 months, okay, before the expiration of the tenure, okay, of the local government administration that will want to expire. I hope you understand. Sorry, 3 months to the okay of the local government election, and that there must have existed a vacancy in the election or in the seat that they intend to conduct election to fill. That's what section 13 subsection 4 says. Are you going to the elongation of local government chairman tenure? Is that where you're going to now? See, that you just made mention of the issues, crisis, state and the impact. And so I am responding in view of that question. Now, that issue that, the conducting of that election in view of an extension of tenure of the local government administration is part of the problem. So then, we must be very, let us be very liberal here. As I when the House extended the tenure or made intention or made a notice that they were going to extend the tenure of the local government chairman, these issues are not really started. The issues are not really started. The issues are not really started. Now, to the antis, they knew the House was resolved to make an extension of this tenure for 6 months. It was after people started going to court. So there was an extension by resolution of the House. So in your opinion, so there was no vacancy, as at the October 5th to conduct. There was no vacancy. There was no vacancy. There was a 6 months extension. There was no vacancy. Tenure expired, ordinarily expired by June 18th. Okay, June, July, August, September, October. It's about 4 months. 4 months. Do you get it? Tenure extension was still on. And then you conducted the election. That is in breach of that section 13, subsection 4 of the same Rivers State Electoral Law number 2.
So in this instance, the outside outgone local government chairman, why are they not?
Not outgone. You can't call them
Hold
outgone.
on. For now, are they occupying the secretariat?
Who is
So
occupying the secretariat? These current the people that are parading, are they occupying the secretariat? How many of them are?
Let's not mix things up. So we
are
don't
not.
confuse.
But I'm just trying to talk about the crisis.
Confuse our viewers. They are not currently occupying the secretariat. The FAC allocation, the local government allocation, is not going to them.
You can call them embattled, but not outgone.
Embattled.
Because
okay,
matters
let's use the word embattled. Now, that's actually where I was headed to. Have they taken this matter to court? The embattled local government chairman.
Of course, matters are in court. Of course, I mean, a lot of matters are in court, touching on the subject matter.
Now, I am talking of not individuals here, but the embattled chairmen themselves.
The matters are covered. Of course, the local government chairman, the chairman have gone to court. They are in court. And then the matters are even covered by... There's a matter currently at the Supreme Court that Victor Okojombo and the governor, with respect to his Excellency, has appealed. In that appeal, that extension is there. I hope you
Actually, there is a Supreme Court judgment. I thought you would be making reference to the local government autonomy, the Supreme Court judgment in the local government autonomy, because the
local government autonomy judgment...
When the Supreme Court was giving judgment on the local government autonomy, people were thinking it was just the financial autonomy. There were also other aspects of local government governance
saying
that the
House
Supreme
of
Court
Assembly
judgment, hold on, that the Supreme Court judgment touched upon. And one of it was elongation of tenure.
Yes.
Where that was paragraph 16.
Yes.
I think page 16.
Yes.
It was on page 16 of that Supreme Court judgment, where the Supreme Court was saying that the House of Assembly has powers to extend the tenure of local government chairmen by a period not exceeding 6 months.
Yes.
And they went further to say that it can only be done when it is impossible to for elections to hold. That the House of Assembly of a state can extend the tenure of local government chairmen. And he said that if the tenure of this local government chairman are being extended, it is the mandate of the people that is being extended. But if it is being truncated, it is the mandate of the people that is being truncated. So now when you're saying that it's also in Supreme Court, Supreme Court had given a judgment prior to this time.
No. What I mean is this. The Supreme Court appeal I mean is there was an appeal that Justice, they couldn't conclude the proceeding here. So, as we speak today, the Speaker of Rivers State House of Assembly is Right Honorable Chike Martins Amewu.
All right, Honorable Don. Talking about speakership, I think it's time to move over to the next story. Initiative for Transparent Strategy and Good Leadership has criticized remarks made by Senate President Godswill Akpabio concerning the ongoing political crisis in Rivers State. Akpabio had referred to Honorable Martin, Speaker of the Rivers State House of Assembly, and acknowledged 26 others as authentic members, sparking controversy. Akpabio made these comments during a public lecture in Port Harcourt held to celebrate the birthday of the Minister of the Federal Capital Territory, Chief Nyesom Wike. He suggested that if Governor Siminalayi Fubara refuses to cooperate with the Amehule-led assembly, the lawmakers would proceed with their constitutional duties, stating that not even a court could prevent them. Reacting to the statements, ITSGL President General Barrister Enyi condemned Akpabio's comments as divisive and detrimental to peace in the state. Enyi noted that Akpabio should have remained neutral as Senate President, especially since Amehule and the others had defected from the People's Democratic Party to the All Progressive Congress, which, according to Section 109 of the 1999 Constitution as amended, invalidates their membership in the Assembly. Any questioned Akpabio's reference to actions the lawmakers might take against Governor Fubara that courts could not halt, he that the statement likely alludes to impeachment. And he further expressed concern that Ababio's comments might escalate political tension in Rivers State, accusing him of attempting to support Wike in leveraging federal power against as compensation for Wike's backing of his Senate presidency. Honorable Don, what do you make of this story?
I need to set the record straight. I was at that event that day from the start to the end of the session.
That's the celebration of the FCT.
I was inside right just at the first row, just before the first row of that program, where the Senate President and the FCT Minister sat. I listened to the the Senate President. I did not think, and I'm of the view, that the Senate President did not make comments like, if the court is not ready to...
At the court, what was saying that Ababio said that if Amehule led House of Assembly should, invoke their constitutional powers to when they perform their constitution.
The law is clear. The court will not stop a House of Assembly doing the right thing, performing its duty, legitimate duty, from doing it. The court doesn't have the power. The court can only stop a House who is doing something that is not lately being done. I hope you understand. The court cannot account any insignificant number of a member of House of Assembly legislate or make a resolution on behalf of the entire state, on matters of public importance. That judgment is there. You think the Supreme Court is not guided? They are guided. They are guided. We are not in a banana republic where you choose what you want to do. You pick the banana you want, you run away, you eat it, you come back, you pick, you run away. No. This is not a... We are ruled by a body of laws. And so, the issue... The matter is, people defected. No problem. People carried flag. That you say they defected, you say they carried flag. The issue is, have you been... Defection is a procedure. Have you met those conditions? Have you met? I am married. This is my wife. Show us certificate of marriage. Do you get it, Lorenzo? Show us out, Lorenzo.
I get what you're saying. You're saying that televised defect as defection. Now, on that's on one hand, and on statutory defection. All right, televised defection does not amount to statutory defection, and it's in this instance the court is not concerned about the televised defection. The court is concerned about proof of defection as provided for by the Constitution. The party constitution.
Law, yes.
We have two constitutions here: party constitution and Nigerian constitution.
That's why we said by statutory provisions. Statutory provisions is the law. It can be a small party guideline.
All right.
It can be the constitution of the party, or what. But those provisions that is required, even constitutionally.
So number one, there has to be. Let's slate it the way you. Number one, there has to be a written letter to the world. And that letter has to be ratified.
It doesn't. Once you sign it, and then followed by an action deregistering. There is no national membership of PDP or whatever.
Now there has to be deregistering. So when the ex-wife party, when the court assesses their register, your name is current. Okay. An exhibit of that, and then the party that the person has defected to, it's expected that the person's name will be in the register.
The person's name will be in the register now.
Interesting. And then, however, Tony Okocha has come out to say that these people are not in the party register.
They are not in during the period that these issues was going on. That they, in the one of the affidavit that defection, we on this day we say we no longer be member. You understand that kind of it. Now, when they serve these processes on the other parties, including Okojombo and the likes, they came to court, Federal High Court, Abuja, And they told the court that we have been served. Felt it was no longer necessary because of other matters before the court that also touches on those subject matter, and apply to withdraw the application. They are originating processes. And it is a matter. Will you force them to remain in court? After all, issues have not been joined. They withdrew the affidavit. So what is the why is it all of a show of animosity that they withdrew the application, that they swore that they defected from this party and all that? I hope you understand. Why? So, see, the public must allow this matter for us as lawyers to look at. They are even part of the problem, because when they share this emotion, sometimes it can kill somebody before you hear from the person. I've not seen a period that is more than this when the judiciary have faced a lot of humiliation, hate speeches, and the like. And then, furthermore, this other issue that has to do with Justice Joy Alumalik's judgment that has to do with the cessation of the public funds and all that.
Yes.
You remember that the Court of Appeal, setting aside the orders made by Honorable Justice Joy Alumalik of the Federal High Court, stated that it was a subject matter jurisdiction, and the matter was to be set aside because it felt that the court did not have jurisdiction to handle the matter. But if we go to section 251, so that is the problem. We will have been. I am concerned. I'm not concerned. I'm not concerned about the elites. I'm not concerned about the elites. I'm concerned about the people. Obviously, people would have suffered. But why don't we stop that we make the people suffer?
Which is what?
Which is the inability of the government of Rivers State and the government to follow the provisions of the law, the constitution. That's what we mean. Why don't you leave this in and do the right thing? In the eyes of even a moral man, can two person become a constituted house of, who is the speaker, who is the majority leader, who are the members, who passes these laws? And you know that the constitution, section 4 of the Constitution of the Federal Republic and section 11, every resolution that is made, every law that is to be made by the House will be made by resolution. And the law has stated that 2/3.
All right, very well.
And I have told you on this program, I think section 158 says that the House of Assembly at no time must not be less than. I've given you a number. Must not be less than 20 or 24. Sorry.
24.
Must be,
and the House of Assembly members must not be less than 24 members.
Beautiful. Person should be asked, the governor should be meant to answer that question.
Well, I'm asking you.
Am I the governor?
Interestingly, but you have a lot to say about Rivers State crisis, don't you?
Obviously a lot, but
you have a lot to say, so I expect you to also have something to say.
But I choose not to say. I'm not the governor.
You cannot withdraw yourself from speaking. I mean, you've been talking a lot about the budget.
The governor,
you have the opinion that the allocation should have been withheld from Rivers State. You have spoken so much. On one part. On the other part, is the governor waiting for the Supreme Court judgment to know whether the judgment will go in favor of Martin Samuel or in his favor, and then if it's in his favor, then he can move on to Okojo. But even if it's in his favor, can the governor legislate with 4-man assembly?